talk about some of the most recent updates for processing and cases both before U.S. Citizenship and Immigration Services, as well as the Executive Office of Immigration Review, which oversees all of the immigration courts in the country. We'll also talk about the public charge rule and how that interplays with COVID-19 and some of the resources and benefits that folks might be trying to tap into to get some extra support right now, as well as the CARES Act stimulus check and the 4CT card, which is a very recent development in Connecticut trying to bridge the gap for some of our undocumented families who were not covered through that CARES stimulus check. The last thing we'll talk about is the quote-unquote immigration ban, which was announced via executive order in April and remains in effect through the end of this month. As Sherry Ann said, I would welcome any and all questions that you might have during the presentation afterwards. I'm also happy to follow up with anybody after the fact if I don't have necessarily the precise answer or might need to do a little follow-up, but definitely want to make sure that we get you any answers to questions you have. So the Victim Rights Center focuses specifically on providing legal services, primarily civil, to survivors of sexual violence and other crimes. We do provide representation in criminal court, but I just want to clarify that that is representation of the victim. We do not do criminal defense. So we represent the victim's rights in the process against the defendant, the perpetrator. We can also help with, communicating or making reports to police, following up with investigations, as well as Title IX cases, CHRO or EEOC claims regarding the workplace and discrimination, housing issues that are connected to the victimization, orders of protection, and of course, immigration relief. We focus primarily, as I said, on sexual violence, but we are also able to serve victims of other serious crimes such as stalking, homicide, elder abuse, and hate crimes based on membership in the LGBTQIA community. Our catchment area for non-immigration cases is based on not where the client lives, but where the crime occurs. So as you can see here, we are able to assist with cases where the crime occurred in Middlesex, Hartford, or New Haven County, as well as Bridgeport, Easton, Fairfield, Monroe, Stratford, and Trumbull. We are looking to expand our service area in the coming years, and hopefully we'll be able to certainly broaden through Fairfield County and the rest of the state. But for now, this is our the area that we're able to assist with. For immigration cases, it does not matter where the crime or the harm occurred, and that includes if the crime or harm occurred in home country, so long as the client resides in Connecticut. So just note that that catchment area is a little bit different for those folks seeking immigration assistance. If anyone does have a client that they'd like to refer, or if there is someone who themselves is seeking services, they can either call us directly. Our office number is listed there. We also have a referral form that can be filled out either by a potential client, an advocate, or we can fill that out with somebody over the phone if that's more comfortable. Just to note that that form is password protected, and I'm happy to share that with Sherry Ann along with the slides for today so we can circulate that. If anybody does want that password, I'm happy to say that now. And if you don't happen to write it down, no worries. You're welcome to shoot me a text or email later on, and I'm glad to give that again. We're just trying not to share that via email for security purposes. So if anybody has a pen ready, the password for our referral form is vrcct.referrals. And a good way to remember that is it is our referral email listed there on the screen, just with a period between VRCCT and referrals. You're also welcome to email myself or any of our other staff members directly. We want to just make sure that we are as available as possible in whatever way is most convenient for potential clients and those advocating for them. So the first type of humanitarian relief or immigration status that I want to talk about is the U non-immigrant status, or what we call the U visa. This type of status was created with the intent to increase the likelihood and willingness of undocumented victims of crimes to come forward and report crimes to the police and cooperate with law enforcement to prosecute and investigate those crimes, understanding very much that undocumented victims of crime often are very fearful, and for good reason in many ways, especially if they've experienced harm or corrupt police forces in their home countries, they are often very fearful of coming forward and reporting those crimes. So with that in mind, Congress created this U visa for undocumented survivors of certain serious crimes who have helpful information, and they share that information with the police, with law enforcement in some way. You do have to be able to provide what we call a certification of helpfulness. So it's not just enough that the applicant, right, so the undocumented survivor, it's not enough that they say, you know, hey, I had this information and I helped police. You actually have to get this certification signed by a member of law enforcement saying, yes, you know, this person had X, Y, and Z information about this crime and they provided it to us. They've continued to be helpful throughout the investigation. It's important to note that the person who can sign that certification can be law enforcement, can be police officers, but it's not limited to that. It can also include judges and prosecutors, and in Connecticut, DCF. So not all states would allow for the child welfare investigative body to certify, but in Connecticut, DCF is able to certify U visa cases because they have that investigative capacity in our state. With respect to the qualifying crimes for a U visa, as I said, they are specific and very serious crimes. So it's important to keep in mind that not every crime will make somebody eligible for a U visa, but certainly sexual crimes such as rape and sexual assault would fall within those that qualify someone for a U visa. In addition to showing their helpfulness to law enforcement, an applicant for a U visa also needs to show that they suffered substantial physical or mental abuse as a result of the crime. And then they also have to show that they are what we call otherwise admissible to the United States. And we don't have to go into too much detail about that today. Just suffice it to say that there are a list of other requirements that anyone seeking to gain lawful status in the United States has to show that they meet. And so an applicant for a U visa would have to show that they meet those admissibility criteria or qualify for a waiver if one of them applies to them. As far as the benefits of a U visa, there are certainly many, of course, one of which is that it is a form of legal status, which will allow somebody to remain in the US lawfully for up to 4 years once the U visa is approved. Additionally, 3 years after somebody receives a U visa, they are eligible to apply for lawful permanent residence or a green card. So this is what we call a pathway to citizenship, meaning that if somebody is able to receive a U visa, they are put on a path that could eventually put them in a place to be eligible to naturalize and become a naturalized citizen, which is obviously a huge benefit. Somebody with an approved U visa also will be able to get lawful employment authorization to work legally in the United States, and they may be able to include certain qualifying family members as part of their case. So if their case is approved, that family member will get derivative U status and also be able to eventually apply for legal permanent residence. One important thing, and perhaps the biggest downside to the U visa, is that there is this fiscal year cap on the number of these visas that are available. So there are only 10,000 U visas available every fiscal year. And we have met that cap for many, many years in a row. So there is a long wait list before somebody can even have the underlying U visa case approved. There's not a precise science to this, but the best estimate is about 5 or so years. I will say that that number definitely seems to be growing each year as more folks are becoming aware of the U visa program and more advocates are pushing for this and applying for their clients. So there is quite a long wait period. There can potentially, depending on the underlying circumstances, be the possibility that somebody could get sort of a provisional approval during that time, in which case they would then be able to get work authorization. But we definitely are seeing those a little less frequently now. So it's something just for folks to keep in mind if this is something they are considering, that it is a long, long wait period to wait out. But again, if this is the only option, certainly can be worth it. The next type of status that we'll talk about is the T visa, or the T non-immigrant status. Similarly, this form of legal status was created for victims of very specific crimes. In this case, we are talking about survivors of human trafficking, and that can be either labor trafficking or sex trafficking. Applicants for a T visa have to show that they are physically present in the United States on account of the trafficking. And although they don't have to provide a certification of helpfulness the way a U visa applicant does, they do have to comply with any reasonable request from law enforcement to assist in the investigation of that trafficking. I will note that although that certification is not required, it certainly can help strengthen the case. And in a time where I think across the board, immigration cases are certainly becoming more and more challenging to get approved, we as advocates are always looking for ways to strengthen a petition, and getting a certification of helpfulness can certainly help, even though it's not required in a T visa the way it is for a U. Similarly to a U visa, T visa applicants also have to demonstrate harm. In this case, the standard is extreme hardship, which we define as unusual or severe harm, and that would be if they were removed from the US. So in that situation, it could be, there's potential danger in home country, or maybe, the client is suffering from mental health issues as a result of the trafficking, PTSD, depression, anxiety, and they're receiving services here that would not be available to them in home country. So documentation of some sort of physical or mental abuse is not required the way that it is for a U visa, but again, can definitely help, because it will really strengthen that T visa case. And also similar to the U visa, T visa applicants also have to show that they are otherwise admissible to the United States. The benefits of a T,
sorry.
No, that's okay. I'm happy to pause.
There's one question. It came right when you were in the other slide, so I think it can go for both. But it says if someone has children that are born here, do some of these constraints vary?
So if that person is able to clarify what they mean by constraints, that would be great, just so I can make sure I'm more precisely responding to the question. But I would say that having US-born children, so US citizen children who were born here, that does not impact one's eligibility, right? So it doesn't make somebody ineligible or more eligible for either of these statuses. However, where that can potentially come into play is, I talked about those admissibility factors, right? And those are things like, criminal history, violations of immigration laws, including entering the country without documents, and being here for an extended period of time without any legal permission. So those are some of the ones that we see most often. So if somebody has one of those inadmissibility criteria that applies to them, and we'll talk about a U visa or T visa applicant, they may be able to apply for a waiver, basically saying, hey, I entered the US without any documentation, which was in violation of the immigration laws, and I understand that that was not a good thing. However, I'm asking that immigration basically forgive that violation, because it would be in the national interest. It would be a humanitarian reason why that would be beneficial. And the waiver process for a U visa and a T visa is much more forgiving than for other types of non-humanitarian immigration status. And one factor that could definitely play into an attorney presenting a waiver, why their client should be eligible for a waiver, is if they do have US citizen children here, particularly if they are the only caregiver for those children. So I'm not sure if that precisely responded to the question, and if we do have any more clarification, I'm happy to.
Thank you. No, that's good.
Thoughts. Thank you for that question too. Sherry-Ann, any others before I jump back in? Just want to make sure I'm
not at the moment.
Okay, perfect. Thank you so much.
Yep.
So the benefits for a T visa are very similar to a U visa, right? So we see here that somebody with a granted and approved T visa can remain in the US legally for up to 3 years. Similarly, they can also be eligible to apply for legal permanent residence 3 years after receiving that T visa. They're eligible for work permits and also can include qualifying family members in their petition. One difference with the T visa, and one very big benefit, is that T visa, individuals with approved T visas are actually eligible for refugee benefits. Those are federal benefits, including cash assistance and other really great things that can help survivors start healing and really gaining independence after the crime. And those are only available to asylees and refugees other than T non-immigrants. So that is a really, really great benefit for our clients and helping them kind of get back on their feet after this horrific experience. One other benefit to the T visa is that, like the U visa, there is a cap, and for the T, it is $5,000 per fiscal year. However, unlike the U visa, we have yet to meet that cap. I think we came very, very, very close in the past year, but we haven't actually hit it yet. And so that means that there is no wait list. So there's no 5-6 year wait as there is for the U visa. That's not to say it's something that happens overnight, because I think any type of immigration case definitely tends to take quite a while, but at least you don't have that extended waiting period, which certainly is very anxiety provoking, and understandably so, for clients just waiting for a response. The next type of relief I'd like to talk about is the VAWA self-petition. So this was enacted through Congress through the Violence Against Women Act, recognizing that abusers often use immigration status as another method of power and control. Under normal circumstances, if somebody is married to a US citizen or a legal permanent resident, that spouse with lawful status may be able to petition for the undocumented spouse to get a green card, to get legal permanent residence. But again, understanding that many times if you have an abusive documented spouse, they may use the other spouse's undocumented status against them, threatening to call ICE, threatening not to submit the petition for them, threatening to withdraw the petition. They use that as another way to continue the abuse. So through VAWA, Congress created this carve-out allowing for spouses and children of abusive US citizens or permanent residents, as well as parents of abusive US citizen children, to be able to essentially petition for themselves. So they cut the abuser out of the process, and where the abuser would normally be the one putting forward a petition, in this case, the survivor gets to put forth the petition for themselves. In order to be eligible for a VAWA self-petition, as I said, you have to be a spouse or child of a US citizen or permanent resident, or a parent of an abusive US citizen. If you are basing your VAWA petition based on marriage, you do have to prove that it was a good faith marriage. And that can be shown with a variety of different types of evidence, photos, shared bills, basically anything documenting to show that it was a legitimate marriage and not solely based for immigration benefits. The applicant also needs to show that they suffered battery or extreme cruelty, that they reside in the US and at some point lived with the abuser, even though they do not have to at the time of applying, that they have good moral character, and that is a specific legal term in immigration law, but more or less just kind of showing that they don't have any negative factors in their history, and again, be otherwise admissible to the United States. Benefits for the VAWA self-petition include the ability to include certain family members, again, as we talked about with the U and the T. And once that underlying petition is approved, then the VAWA self-petitioner can apply for legal permanent residence without the knowledge of the abuser. They never have to know. They are completely disincluded from the process. And they can apply for work authorization even before their green card application is approved while it's still pending. Two other things that I would just mention with this is that there are these other two forms of relief that often go hand in hand with the VAWA self-petition. One is the battered spouse or child waiver, and the other is something called VAWA cancellation. So the battered spouse or child waiver is applicable where, let's say that abusive spouse already submitted the initial petition, and then the green card was conditionally approved, which is what normally happens in say, a marriage-based green card case. Once it is approved, the undocumented spouse has their green card, but it is a conditional green card. And after 2 years, they have to apply to remove those conditions to show they're still married and it was still a good faith marriage, all of that. So if the survivor has that conditional green card, and now the abuser either is refusing to continue with the process for the removal of conditions, or the survivor has separated from the abuser and wants to continue on their own, they may be able to ask for a waiver essentially of that removal of conditions of the US citizen or permanent resident spouse's participation in that as a battered spouse or child. So they are kind of, again, cutting them out of that process, and at that point it would be the removal of conditions piece. VAWA cancellation is something that is available to individuals who are in the deportation process in immigration court. And cancellation of removal is a type of relief that may exist even for people who are not survivors of abuse, but there is a special type of cancellation of removal under VAWA, again, for individuals who have been abused by a US citizen or legal permanent resident spouse or parent. And they may be able to apply in front of an immigration judge to essentially cancel out their removal, their deportation process, and be able to get a green card, get permanent residence. The next type of humanitarian relief that we'll touch on is something called Special Immigrant Juvenile Status, which is often abbreviated to SIJ or SIJ. And this is for minors, so under the age of 21 who are unmarried, who have been abused, neglected, or abandoned by one or both parents, and therefore cannot reunify with that parent or parents. This is the only immigration process that actually requires and involves a state court order and a state court process to be eligible for the immigration benefit. So in this situation, an individual who wants to apply for SIJ has to first go to the juvenile court in their state. In our case, it is usually the probate court, and have a judge in that juvenile court, so for us in that probate court, enter an order stating that the minor is dependent on the court or in custody of a state agency and unable to reunify with the parent or parents who inflicted the mistreatment. The judge also has to make a determination that it is not in the best interest of the minor to return to their home country. Once the minor has that order from the state court judge, they are then able to take that as proof of their eligibility for SIJ and apply to immigration, to USCIS, for that special immigrant juvenile status. Once the underlying petition is approved for SIJ, then the minor would be able to apply for a green card for permanent residence. And at that point, they would have to show, as with the other forms of status we've talked about, that they are otherwise admissible. I will add that similar to the other forms of humanitarian status, there are a slew of admissibility factors that do not apply to special immigrant juveniles, including unlawful entry and working without authorization. So whereas those might be issues for other types of immigrant categories, for minors applying for SIJ, those would not be a barrier to them getting a green card. I will note that there is a significant wait period for minors who are applying for a green card based on SIJ who come from Guatemala, El Salvador, and Honduras. Basically, the minor has to wait until a visa in their category, in this special immigrant juvenile category, is available. And in those three countries, there's about a 2-year or so wait. It's not necessarily moving at the rate of, one less day by day. It moves maybe every couple of months. So I say 2 years now, but that definitely could increase. And yeah, so just something to keep in mind for minors who are from those few countries, that there is a wait period. And while they are waiting for a visa to become available for them to apply for that green card, they are not able to apply for a work permit. So that is not until they are at the point of actually applying for the green card. Something important to note about special immigrant juvenile status is that parents, whether it is the abusive parent or the non-abusive parent, if it was just one, but either parent of the minor cannot get any immigration benefit through that child's SIJ status. So that means if you have a minor who's granted SIJ and gets a green card through SIJ, they are not able to petition for their parents, even if it is a parent who was not mistreating them. That includes even if the child ends up naturalizing, so long as they got that green card and therefore then naturalized through that special immigrant juvenile status. So just something to keep in mind, both when talking to the minor client about this option, but also making sure that if they are in the custody of one parent still, that the parent understands that as well. The last form of relief that we're going to talk about is asylum. And this type of protection is different from the ones we've discussed in that this is focusing on a harm that happened not in the United States, but in home country. So asylum is for folks who can show that they meet the definition of a refugee, in that they have suffered past persecution or they fear past persecution if they were to return to their country. And the persecution that has either happened or they fear will happen has to be on account of what we call a protected ground. So these are certain characteristics about themselves, and they need to show that the harm would be because of that characteristic. And you can see the list there. It is race, religion, nationality, political opinion, or membership in a particular social group. Somebody applying for asylum also needs to be able to demonstrate that they are not able to obtain government protection. And that can be either because the person who is persecuting them is a state actor, it is the government itself, or in the case of a non-state actor, they have to be able to show that the government is unwilling or unable to protect them, the applicant, from that persecutor. And then finally, an applicant for asylum has to show that they are not subject to any bars to asylum. The bars to asylum are similar in concept to those grounds of admissibility we talked about before. These, however, are specific to asylum, and most of them are things that oftentimes do not apply to clients, things like terrorists or persecutors of others. So folks who meet those criteria would not be eligible for asylum. But there are other bars that are really important to be mindful of and oftentimes can be very problematic for asylum seekers. One of them is something called a one-year deadline, which is that somebody has 1 year from the day that they enter the United States to apply for asylum if they want to. There are some exceptions, but they're limited and they're definitely difficult to prevail on. So wherever possible, we try to have folks apply and submit their initial paperwork within that 1 year period to preserve that deadline as much as possible. If somebody is granted asylum, they have indefinite legal status in the United States. So this is another point of differentiation from maybe a U or a T visa, which grants legal status on a temporary basis for 3 years or 4 years. Somebody with asylum can theoretically remain in the United States lawfully and for an indefinite period of time. However, most often, folks do want to take advantage of the fact that they are eligible to adjust status. And so 1 year after being granted asylum, asylees are able to petition for permanent residence to get a green card. And then similarly, can also be eligible to naturalize down the road as well. As I mentioned, asylees are also able to tap into those federal refugee benefits like the cash assistance. And there's also some employment assistance as well. They are able to include family members on their petition. So for example, if they have family members here in the United States with them, qualifying family members, they can include them in their petition and that family member will get derivative asylum status if the applicant's case is approved. If they have qualifying family members back in home country, once their asylum case is approved, they may also be able to apply for those qualifying family members to come and enter the United States as derivative asylees. And that is a really, really big benefit because certainly we have a very robust family-based immigration process for other categories of immigrants, folks who have legal permanent residence and citizenship. And that's always an option for an asylee to wait until they get their green card to petition for family members. However, the admissibility criteria for an asylee is much, much less than somebody who is entering not as an asylee. And so there are a lot of really, really great benefits and it can be a faster process petitioning for somebody as a derivative asylee rather than through the normal family-based immigration process. So I'm going to take a pause here before we start talking about some of the impacts of COVID on both immigration processes and our immigrant communities, and just check in with Sherry Ann to see if we have any questions or if folks want to jump in and ask anything before we move on.
I don't see any questions, but I have one.
Okay. Sure.
So I know in the beginning you mentioned about like if the abuse happened in their country and think it was the slide before, you were mentioning certain countries. So would you be able to help folks with TPS?
Yes. Sorry, I apologize for the hesitation. To be completely honest, Maura and I, our program director, we hadn't discussed TPS as a potential case that we could take on. However, I think that if the client fell within one of our covered victimizations, and I'll just maybe scoot back to that slide. So if the client was the victim of one of these crimes, whether it was related to the TPS or not, and they were otherwise eligible for TPS, yes. Although I will say that TPS is kind of definitely becoming more difficult, obviously, since the Trump administration kind of came in, they've been working to end that program and certainly have stalled it, if nothing else. But yes, I think that if they fell within those victimizations and that was what they were eligible for and seemed like the best option, then sure.
Oh, and we have a question. What about entrance to the U.S. under these visas for transgender LGBTQ parties seeking refugee?
Excellent question. So,
and I'm sorry, and there's a second part. Any special provisions for this group?
Great, I love that question and very appropriate in light of Pride Month. So thank you very much for raising that. So there are not any specific provisions in the law or in the regulations delineating that group in particular. Most of the guidance that we get on asylum eligibility comes not from the law or the regs, but from case law, meaning judges have looked at certain cases and made decisions, and we are then able to look at that decision and compare those facts to the facts of our case and say, hey, this person was deemed eligible for asylum because they were part of this social group. And my client is similar to that in these ways, and therefore she should be eligible for asylum. So in that way, there absolutely is a robust amount of precedent and case law regarding the eligibility of members of the LGBTQIA community for asylum. So for instance, I am currently representing a gentleman from an African country. He identifies as bisexual, and he suffered persecution at the hands of both his family members and community members and members of his religious organization. He identifies also as Muslim, and so members of his faith did not believe that it was appropriate or okay for him to identify as bisexual. And so we are in the process of seeking asylum for him. So certainly that is membership in the LGBTQIA community has been recognized as a membership in a particular social group for asylum purposes. I will just mention, and this is not anything that any non-lawyers necessarily have to worry about, but just as sort of a disclaimer that all asylum cases do have to be decided on their individual merits. So I say that there is precedent for LGBTQIA to be a basis for a particular social group in asylum case. However, you would still have to be able to show why that is the case in your client's circumstances. But yes, absolutely. I will mention that it's not perfect by any stretch. And I think in particular, trans individuals who are seeking asylum have faced some difficulties, and that often can depend on where they are in the country. Asylum adjudications, to be frank, are very subjective, and you can have very similar facts in front of two different judges in two different courts and get two different outcomes. So we are fortunate in the Second Circuit, which is the circuit court that covers Connecticut, that for the most part, we've got pretty positive case law here. Also, our immigration court in Hartford, we have fairly positive rates of approval, asylum approvals from our immigration judges there, but it is certainly not a perfect form of protection. Although absolutely, I would say that if somebody is fleeing violence based on identifying as LGBTQIA, that could certainly be a basis for them to seek asylum.
Thank you.
All right. So I'm going to fast forward. There we go. So now I want to talk about, as I said, some of the ways that COVID has impacted all of these systems. and our immigrant communities specifically. So first, let's talk about USCIS, and that is the United States Citizenship and Immigration Services, which falls under the Department of Homeland Security, and they are charged, or supposed to be charged with, deciding and divvying out affirmative asylum benefits, right? So for folks who are not in deportation proceedings with an immigration judge and are applying for some type of immigration benefit or status. So many of the statuses that we've talked about today, folks would be applying to USCIS to seek those forms of protection. I did say that they are charged with being the ones to decide these benefits, because more and more, unfortunately, we are seeing USCIS being utilized as an enforcement branch of Department of Homeland Security, which of course there is something, there is a branch already designated for that, which is ICE, so Immigration Customs and Customs Enforcement. But we are unfortunately seeing more and more that USCIS is essentially having very similar enforcement-like functions, even though that is not what the agency is intended for. So that being said, during COVID, USCIS offices were closed to the public for a period of time and not doing any in-person services. However, some offices began to reopen on June 4th. Hartford, which would be our local USCIS office, also reopened on the 4th, and they did begin limited administration of naturalizations of citizenship oaths on June 8th. They're notifying attorneys and individuals by phone. So if folks have something pending before that office, they should be getting a call, or their attorney should be getting a call. And as of right now, based on the information that we have, aside from those limited oath administrations, because they're not even the ceremonies, because that would be too many folks in a room, there are no other appointments that we're aware of that are being scheduled right now. Generally speaking, for any appointments or info pass requests, anything like that that was scheduled and was canceled because of COVID and because of the office shutting down, we anticipate that those would be rescheduled, and USCIS would be reaching out to the individuals as that rescheduling happens, although surely it will probably be slow going. There are guidelines in place for anyone who is entering a USCIS facility, and I have the link below there to USCIS's response about COVID-19, where you can read a little bit more about the specific requirements and guidelines if anybody does have to go to one of those offices. For any biometrics or fingerprint appointments, those are still not happening. Those will resume at a later date, but we don't have a specific time frame right now. Again, those we anticipate, folks would just be contacted either via phone call or notice of some kind, letting them know when they should come into the office for that rescheduled biometrics appointment. It's important to note that prior to this, limited reopening and now, individuals can still submit applications and petitions for immigration benefits, so that has not stopped. Certainly, I imagine that things may have slowed down a bit, but USCIS is still receiving petitions and applications. And for individuals who are here in the US with some sort of temporary status and may need to extend that status or change it, there is some flexibility for the applications to do both of those things. Information about that is also included on that USCIS COVID response page. So I would just encourage folks to take a look at that if it's something that's relevant in your case or clients. And Sherry Ann, did I see a question come through? I'm just trying to be mindful of that so I don't miss anyone.
I just shared the link so that if in case folks want to bookmark it, they can just click on it and have it.
Excellent. Thank you so much for that. Yeah, all I see is a little alert, so I can't tell quite what it is. So let's now switch to talking about the Executive Office of Immigration Review, which, as I said before, is the body or the agency of the Department of Justice that oversees all of our immigration courts and our appellate body for immigration law, which is the Board of Immigration Appeals. So there are two types of cases that might be in immigration court. I'll just mention that as sort of a preliminary thing. There are detained cases and non-detained cases, so individuals who are currently in immigration detention and in the immigration court process, so having to appear before a judge, remotely or whatever that looks like. And then there are non-detained cases, so individuals who are still in that deportation process, but they may be have been, bonded out of immigration detention, or they have an ankle monitoring bracelet, or they're checking in with ICE, or some alternative to detention is in place. So all non-detained hearings throughout the country, any court, I think the only exception is Honolulu, but all non-detained hearings have been rescheduled through and including June 26th. This is important just to note that individuals who have submitted or were planning on submitting asylum applications, this postponement of their case, and I won't go into the mind-numbing details about why this is the situation, but it could be good news in that it may actually make them eligible for work permits while their asylum cases are pending. So that's just something I want to flag for individuals who have applied for or were planning to apply for asylum, that they should consult with their attorneys to see if that's something that might be an option for them, and a bit of a silver lining to an otherwise stressful period. As courts are slowly starting to reopen, it really seems to be sort of a court-by-court decision right now. Pending any additional national guidance. I've been hearing from listservs throughout the country that some folks are not getting any information. Places like Boston just announced that the Boston Immigration Court will be resuming non-detained hearings this coming Monday, or excuse me, June 29th. And other courts are waiting for their attorney general to make a call. So it's very, very all over the place. For Hartford, we do not have any additional guidance at this point. So we don't know when they might be resuming non-detained hearings in the Hartford Immigration Court, or what that's going to look like. If anybody does have any questions about that, please feel free to reach out to me. In addition to my position at VRCCT, I also serve as the treasurer and the EOIR liaison for the Connecticut chapter of the American Immigration Lawyers Association. So I would hopefully, fingers crossed, be one of the first to know with any updates for the Hartford Immigration Court, and I'm happy to share that information as soon as I have it. Just important to note as well that there is increased flexibility for attorneys and respondents to appear telephonically, and also flexibility regarding filing of documents electronically during this period. And any information about specific measures that are in place at a certain court can be found at the link below, which is EOIR's response to COVID-19. One other thing, actually, I apologize, I'm just going to go back very briefly. One thing that I do just want to flag is that it is very, very important under any circumstances for somebody who is in removal proceedings to not miss any court date. If they miss a court date, they may be ordered removed, deported in absentia. So in their absence, the judge can issue a deportation order against them. And that is the circumstance no matter what. But I just want to raise that because there, of course, has been a lot of confusion as rescheduling notices have been sent out, and then more rescheduling notices have been sent out. Excuse me, and a lot of people are not aware of when their court date is, or if that's still the court date, or what they should do. So just something to flag, that it's better to be safe than sorry. You can always call the Hartford Immigration Court to find out about the status of your case. And there is also a 1-800 number, and I'm happy to share both of these with Sherry Ann to circulate to everybody afterwards. But there's a 1-800 number that folks can call, and it's an automated telephone system where, as long as you have the individual's alien registration number, or A number, you can look up their next court date. And that should, for the most part, be relatively accurate, even with the rescheduling that's happening. So I just wanted to mention that. The next thing I want to, oh, yes.
I actually, in regards to Hartford, they are really behind in updating the 1-800 numbers.
Okay.
I actually had a client who was supposed to go to court on the 9th, and we called on the 8th, and it was still not updated, saying they're still got court on the 9th. And when I called the clerk, she said they had over 5 boxes of cases that they have not updated, and that it could take a while. So you're better off just calling just to verify, because the 800 number is not up to date, not for Hartford.
Patricia, thank you so much for that. I really appreciate that. So yes, heed Patricia's warning. Just don't even worry about the 1-800 number at this point, and just feel free to call Hartford Immigration Court directly. Thank you so much, Patricia.
No problem.
I have a question in terms of this. So if there's something scheduled, and let's just say the person has COVID-19, Is there a way to reschedule or let them know that you can't make it because you have COVID?
Yeah, so certainly if somebody is represented by an attorney, that's going to make things a lot easier, right, for them to be able to communicate with the court. That's definitely something that the attorney could file, paperwork, file motions with the court to make that representation on the client's behalf. If somebody does not have representation, again, I think my best suggestion would be to start with calling the court and letting them know that. Certainly, as I said, there is increased flexibility for attorneys and respondents, and that includes folks who are not represented, to appear telephonically where appropriate, and with, as long as there is sufficient notice to the court and they're able to make arrangements for that in advance. So I can't imagine that if the court was aware of that, I would certainly hope that they would be happy to make the appropriate accommodations for that individual. But there isn't a specific process necessarily, aside from, as I mentioned, that link there is a list of standing orders for all immigration courts, just outlining the exact processes if you want to request, for example, that your case be continued to another date, or if you want to request that you are able to appear telephonically. So aside from those, I think the best option might be giving the court a call directly for folks who are not represented.
I just also want to point out, thank you, Patricia. She shared the hotline number on the chat box if anyone wants to take that down.
Thank you so much. Coming through for me. Thank you very much, Patricia. All right. So the next thing that I would like to touch on is the public charge rule, which is something that, folks may have heard about last year as that was, being proposed and then amended and then finalized, and how that interplays with COVID-19 and certain services or benefits that people might be looking to tap into during this time. So let's start by defining what the public charge rule is. We mentioned before that there are these grounds of inadmissibility that might prevent somebody from being eligible for an immigration benefit. One of these is something called the public charge rule. And it basically says that if immigration thinks that somebody applying for an immigration benefit is likely to depend on the government for financial support in the future, based on a variety of factors, then that may make that person inadmissible or not eligible for that immigration benefit. The public charge rule has been part of our immigration system and part of our immigration laws for many, many, many years, so it's not anything new. What did change last year was how somebody is determined to be a public charge or not. So the big thing was that immigration is now taking into consideration the receipt of means-tested benefits, in addition to a variety of other factors. Sorry about that. When determining whether or not somebody is a public charge or is likely to be a public charge. So that very understandably created and continues to create a lot of fear and uncertainty in the immigration community when it comes to deciding whether or not to accept a benefit that may be crucial and potentially life-sustaining for their family, or whether doing so is going to put them at risk of deportation or being ineligible for immigration status in the future. So I want to first start by saying that for all of the humanitarian cases that we've talked about today, so all of those types of immigration status, they are all exempt from the public charge rule, meaning it does not apply to them. So although they may be subject to other grounds of inadmissibility, the public charge rule is not one that they have to be worrying about. So if somebody is applying for a U visa and they are concerned about receipt of benefits or anything else that they think might make them a public charge, that is not something that they need to be worried about as far as their admissibility criteria. For other folks who are subject to the public charge, or maybe, right? So if you have somebody who's undocumented and doesn't have any type of benefit application pending before USCIS, but they want to make sure that they don't do anything now that could impact their eligibility in the future if their circumstances change. So for those individuals, it's important to note that there are a number of things connected to COVID that are not going to be considered impacting the public charge determination. So that includes testing, treatment, and preventative care for COVID-19 and related to it, unemployment benefits, tax credits, and that includes the CARES Act stimulus check because that is considered a tax credit, and the 4CT gift cards, which we'll talk about momentarily, as those are privately funded sources. So again, this is also one of those areas that it is important, if somebody has questions about this, to consult with a licensed immigration attorney. But I think that these are just some really quick, easy points to know for advocates or folks who are working with the undocumented community, just to have these quick bits of information at the ready for individuals who have questions before you connect them with an attorney for a further analysis. So I mentioned the 4CT card as one of the things that is not going to be included in the determination of whether or not somebody is a public charge. This is relatively, ooh, I'm sorry. I think I mislabeled my slides. I'm so sorry. So apologies. This actually should say the CARES Act in that headline there. So we'll talk about the CARES Act first, and then we'll talk about the 4CT card. So the CARES Act was a very large stimulus and recovery package that was approved by Congress, offering relief to state and local governments, individuals, businesses, hospitals, and it included these stimulus checks, which were these one-time payments to help individuals and families recover from the economic impacts of COVID. And you can see here that there is basically kind of a scale dependent on income and marital status of how much an individual may be eligible for in this stimulus check. And that number phases out as somebody's income gets higher, up until a point where for certain incomes that are high enough, they phase out completely and are not eligible for any of those monies. For non-US citizens, there is a possibility that some of them may be eligible for that CARES Act stimulus check. And I know that by this time, a lot of those have already been paid out, but I did just want to still include this because I know, at least for a couple of my clients, they are still waiting for those payments, particularly folks who did not file taxes in 2018. So their first tax return was in 2019, and maybe they filed on the later end. Because it is based on tax returns and other information, depending on if folks are receiving monies from other government programs, but primarily based on tax return information that the government is making the eligibility determination. So if somebody filed a little late, it just may take a little while for all of that information to process through, and then for the check to be sent out or deposited. So returning to non-US citizen eligibility, basically, if you have a valid social security number and you meet either what we call the green card test or the substantial presence test, you may be eligible for this stimulus check. So the green card test is pretty straightforward, right? It's if somebody has a green card. So if they have a green card and valid social security number, they should be eligible for that stimulus check, so long as their income would fall within the parameters. The substantial presence test, without getting into too much detail, basically says that for somebody who is not a US citizen or not a green card holder, so that can include individuals with other types of status, so for example, asylees, if they have been present in the United States for a certain period of time, then they also have a valid social security number, then they may be able to get this stimulus check as well. It's important to note that mixed status families may not be eligible for this, and this was one of the big gaps of this Relief Act, which was certainly very helpful and crucial, but unfortunately it missed out for a lot of our undocumented families or folks with mixed status. So because of the fact that you need to have a valid social security number to be eligible for the stimulus check, if, for example, you have a household with two spouses and spouse A is documented, spouse B is undocumented, and spouse B does not have a valid social security number, maybe they have a TIN, and the spouses filed jointly, so their tax return was for both of them, they would not be eligible their family would not be eligible for that stimulus check because of the fact that spouse B does not have a valid social security number. So that was certainly a disappointing piece of this act, and something that the Connecticut ALA chapter did raise with Senator Blumenthal when we had a roundtable with him about a month or so ago. And as a result of this, as well as many other things, Connecticut has been trying to find ways to supplement and bridge some of those gaps for folks who did not benefit from the CARES Act. And one of the ways that they're doing that is through this 4CT card, which, as I said, or started to say, is still very new, so we don't have a lot of information about it. But 4CT is an independent nonprofit in Connecticut that's working with community foundations, health centers, and other entities to basically, coordinate and fund these projects that will give additional financial support to those in need because of COVID. So this 4CT card that is still in the works and should presumably be sort of rolling out in the next couple of weeks is a preloaded gift card, essentially, and they're coming out in the amounts of $200 and $400. And the idea is that individuals who receive these cards can then redeem them for care at community health agencies or for other necessities like food or clothing. The intent is for these cards to go to undocumented individuals or families who were left out of that CARES Act, like I said, so they were part of that gap of folks who were eligible, and also negatively impacted by COVID. There are still additional guidelines in the works and should presumably be forthcoming, but we don't really have much more than that right now. One thing that we do know is that there is not going to be an application process. So the way that this is going to work as far as identifying who is eligible is that community-based organizations who are partnering with 4CT are going to be the ones who identify the individuals or the families who they believe are eligible for these cards. And the thought behind that is that these community-based organizations are already, doing work with the communities. They're very entrenched with the communities, and they would be in some of the best positions to know who really is being hit the hardest and who really is in need of these. So it'll be these organizations who will be identifying and handing out these gift cards, which, as I said, can then be redeemed for services and other necessities. The last thing that we'll touch on today is the quote-unquote immigration ban, which was a presidential proclamation issued back in April that imposed a 60-day ban on the issuance of green cards for most immigrants during the COVID-19 crisis. So this quote-unquote ban was first announced via Twitter, and I think when it actually came out, the text certainly had a little bit less teeth than the initial tweet might have suggested. But it says that as of April 23rd, anybody who is outside of the US as of that date, doesn't have a valid immigration visa in their hands and a valid travel document in their hands as of that date, cannot enter the United States so long as this ban is in place. There are some exceptions, not all of which are listed here, but for example, spouses and children of US citizens and permanent residents. But this definitely does impact a really, really large group of folks who are outside of the US and maybe were waiting for a petition that was filed on their behalf by somebody in the US. The 60-day period is coming to an end later this month, but it could be subject to extension or expansion. So there are some rumors that this may be expanded to other types of visas beyond just green cards. So just something to keep an eye on. The good news is that if you are somebody working with the immigrant community and you have a client in front of you, they are in the US, and so therefore this does not apply to them. So that's very simple. But that's certainly not to say that they may not have family members who are outside of the US who this has impacted. So just wanted to bring that to everybody's attention as something to watch. And with that, I am finished on my end. I hope that we might have some robust discussion with some additional questions. But I did just want to offer up my personal contact information as well as the contact info for our legal team, the Victim Rights Center of Connecticut. So you've got my personal email and work cell there. Feel free to text, call, email, carrier pigeon, smoke signal, whatever works for you. I try to be as available as possible and try to get back to folks pretty quickly. And then anybody looking to contact our team generally can reach out to us via phone, fax. Again, our referral email is there, or our mailing address, which we've got the PO box listed there as well. So thank you again, everybody. And I also just want to apologize. I think my room got significantly darker and the glare on my glasses got significantly stronger as we went, and the storm outside continued to brew throughout the presentation. So sorry for that.
Thank you, Keighly. I also want to add something she did not say. So Keighly speaks Spanish. So if you have any clients that are Spanish speakers or bilingual, feel more comfortable speaking in Spanish, she does. And there's also Nisha, I know she was here somewhere, basically to say that if the client wants to reach out on their own to VRCCT, they are able to if they do speak Spanish.
Thank you so much, Sherry Ann, for calling me out, but that's a good thing. That's good to know. So yes, that's true. So both myself and my colleague Nisha do speak Spanish. One of our other attorneys also speaks Spanish pretty fluently. Additionally, our assistant and paralegal extraordinaire, Nadia, also speaks Spanish and Portuguese. But beyond that, we also have access to language line if necessary. So if we do have a client with additional language needs, we are able to meet that, because we want to make sure that that's not a barrier.
Are there any questions? So I want to give some time for folks if you do have questions. We will be sending out an email. Keighly came up with like a tip sheet, so there will be some handouts that we'll send in a follow-up email as well as an email. So you have more information there. I think we can send out the referral form.
Yes,
right?
I would be
Okay.
happy to. And I'll just repeat one more time, the password for that referral form as it is encrypted. Again, feel free to reach out to me if you lose the piece of paper or the email that you write it down in, but it is vrcct.referrals. So VRCCT as in Victim Rights Center CT.
I'm looking around, I don't see anyone. I don't see any questions.
That's good. Hopefully that means that I answered everything in the presentation, and everybody's immigration experts now. But if anybody does think of any questions after this or encounters any situations that brings up questions, as I said, please feel free to use me as a resource. I am happy to be here in any way that I can.
Thank you. All right, well, thank you everyone. We finished a little early, but I just always want to make sure that there's time for questions and, so that Keighly didn't have to rush. So I appreciate you all joining. Thank you. Have a good afternoon.
Thank you, Sherry Ann. Bye, everyone.
Bye.